Hi, everyone. My name is Sean Tevel. I'm a partner in the Private Wealth Services Group of Holland & Knight in the Miami office. And I'd like to introduce you to one of our newest colleagues, Joshua Odintz, in our Public Policy and Regulation Group based in Washington, D.C. Josh has extensive background, both in the government and in international law firms, and is one of our foremost experts on essentially everything DC and also international tax. So even though he's in the Public Policy and Regulation Group, he actually is one of our foremost tax experts as well. And we'd like to welcome Josh to the firm and sort of introduce him to everyone. Josh, I don't know if you'd like to give a little bit of your background so that the webinar audience who aren't familiar with you can get to know a little bit about you.
Sean, great. Thank you very much. And it's good to be working with you again, since we worked together at one of those international law firms in the past. So as Sean noted, I spent some time in government. I spent 2.5 years at the Senate Finance Committee during the last recession and worked on ACA, what became the ACA, also worked on a variety of stimulus bills. And then at Treasury, I ran the domestic tax team and was responsible for advising the political decision makers on domestic tax issues. Since then, I've spent my time in international tax, primarily on policy, controversy, and planning. The TCJA has provided lots of opportunities for planning, and also I've had to help clients figure out how to unwind certain structures to avoid provisions like the beat or some of the bite of guilty. So Sean, maybe should we get started? Thank you for the introduction. And
sure. So just to give everyone a little bit of background to what we'll be planning on doing today, this will essentially, it's a pretty timely presentation now that the stimulus package has been approved. And I don't know if anyone's been on Bloomberg this week, but 2 days of this week, the first article talked about Biden looking for increases in taxes. So we're going to start seeing more and more articles about these types of issues. And sort of our plan here is to discuss how those changes in taxes, what the tax reform landscape would look like. And then from there, any proposed tax changes, which who knows if they'll actually get through, what that could mean for international clients, whether it be foreign people investing in the US or with US family members, or US families with activities abroad. So that's essentially the plan for our presentation, and we'll kick it off now.
Great, Sean. So I think it's important to set the legislative priorities and discuss what Democrats would like to achieve. So the 2020 election was very much like the 2006 election. The Democrats got a royal flush. They picked up seats and were able to flip the Senate. They have a very thin majority, even thinner than the majority they had in 2006 going into 2007. It's a 50-50 tie with the vice president casting the tie-breaking vote. But there's a lot of pent-up interest in achieving some big policies. And from the legislative priorities, the first is revenue. As you may have seen, our debt has ballooned. I can't count. It's over 20 trillion, hovering around 26, 27 trillion. It's eye-popping. And at some point, Republicans and Democrats will want to bring in additional revenue or cut spending. I think the Democrats would like to increase revenue. The Republicans would like to cut spending. If there's going to be bipartisan legislation, it will have to involve a combination of the two. But Democrats are going to be looking at revenue. Democrats also adhere to a system or a budgeting tool called PAYGO. For every new spending provision or new outlay of revenue, you have to find a new source of bringing in revenue or cutting spending. So that system of PAYGO, and that'll be a popular phrase for the next 2 years, means that Democrats will be looking for every coin under the cushion to pay for priorities. A second theme we're going to see in legislation is addressing inequality. We've seen that in some articles that have run in papers like the Washington Post, the New York Times, about how the tax code has benefited the wealthy during the last 4 years through the TCJA and the average or the bottom quartile, bottom quintile of workers have not seen their wages and income increase at the same pace. So there will be an interest in addressing that inequality. Some of the individuals that have joined Treasury have written extensively about this issue, and I would expect them to try to work with members of Congress to address inequality. That likely means increasing the tax rate on high net worth individuals, focusing um, on transition of wealth to the next generation, and addressing corporate income tax rates. Another theme will be infrastructure and clean energy. I view the two as tied together. A lot of our clean energy provisions run through the tax code. There are a variety of incentives, including tax credits. And I expect Democrats to use the same approach. Infrastructure could be a lot broader than just bridges and railways. So I'm looking to see, are we going to build out our battery network? If you have an electric car, are we going to have charging stations in every rest stop in the country? But there's a lot of different ways that infrastructure can be built out in this country, and I expect the tax code to play a critical role. International tax reform is also on the menu, and we'll get to that in a minute when I get to the big events in 2021. As you may have seen, then candidate Biden ran on international tax reform as one of his platforms, and some of the provisions would be wildly unpopular for multinational businesses and for high net worth individuals. Finally, corporate tax reform. The president is very clear. He would like to raise the rate to 28%. I think a corporate tax rate is coming. Corporate tax rate increase is coming, and there could be additional changes as well, like a revised alternative minimum tax, and we'll cover that in a little more detail in a minute. There are some big events coming in 2021 that will signal where we're going and when. Probably the first big event is one that's not listed, is a hearing that just got noticed for next Tuesday on international tax reform. It will take place in the Senate Finance Committee next Tuesday at 10 a.m. Dr. Kim Clausing, who is the Deputy Assistant Secretary for Tax Analysis at Treasury, will testify. This is the first time we will hear at a hearing from a member of the tax team at Treasury. I expect Dr. Clausing to lay out the vision of the Biden administration on international tax reform. And I think she'll give us a sense of what Treasury intends to do in the next 6 months to a year. Second is the Senate Finance Committee Chairman, Ron Wyden, intends to issue a white paper on tax reform. It will focus primarily on international tax reform. It will contain a range of options. So if this sounds familiar from the Ways and Means Republicans and the Senate Finance Democrats, 5, 6, 7 years ago, that's right. It's going to be options, A through C, X through Z, but we'll see a range of options that will allow policymakers to decide how to reform our international tax system. Once again, we'll have more Senate finance hearings. The hearing next week is just the first in many. The Finance Committee is going to return to regular order on tax, which means a steady diet of hearings, which will reveal where the members want to go this Congress. Then probably the big document I'm looking forward to is the Green Book. So Treasury, as part of the budget process, publishes a Green Book, which is literally a book with a green cover that contains a description of all of the tax provisions in the budget. It is a narrative description, so it doesn't contain legislative language, but it does give enough description to understand how a provision would operate. And it also includes a revenue estimate, very much like a Joint Committee on Taxation revenue estimate. So you get a sense of the potential revenue that a provision could lose or bring in. And I expect that we'll see a substantial amount of the Biden campaign plan reduced to a series of budget proposals, and we'll also see is either part of that document or perhaps separately a Treasury white paper on tax reform. It's unclear if it'll be a separate document, but Treasury and the White House are working together on a tax reform proposal. Next is the OECD's inclusive framework. This is a process that began in 2011, 2012 with BEPS, the Base Erosion and Profit Shifting Project. It has morphed into the inclusive framework. There are more than 137 countries participating, deciding one, how to address taxation of the digital economy. That's pillar one, and basically the elimination of the arm's length standard and transfer pricing, which is terrifying for tax professionals. And then second, and probably the sleeper issue, is pillar two, which is a change to how we tax controlled foreign corporations. And that pillar two is probably the area where countries have put in more thought and agree in principle. And it's a question of, does pillar two move first, or do pillars one and two move together? But the point is that inclusive framework, the OECD is pushing to reach an agreement by this summer. And that agreement could lay out the framework for international tax reform in the United States. And then finally, I just want to point out two cases that are worth watching because they could create chaos in the tax area. The first is CIC Services. That case involves a very, what I would consider not a significant tax issue, but it's really an Administrative Procedures Act issue, and also whether the Anti-Injunction Act prevents a stakeholder from challenging the validity of guidance before an assessment. So let's say a regulation comes out, you don't like that regulation, you think it's invalid. Can you sue the IRS or Treasury before you even take a position on a tax return, challenging the validity of that regulation? Currently, the interpretation in some circuits is the Anti-Injunction Act prevents a taxpayer from doing so. So the Supreme Court will resolve that issue, and that will likely mean that there will be tax legislation to address that issue, because the IRS does not want to fight taxpayers in every forum at all times. And so that could be a triggering event for tax legislation. And then second is California versus Texas, which is a Supreme Court case involving the constitutionality of the Affordable Care Act. And while we're talking about tax reform and international tax reform in our webinar, it's important to recognize that the ACA is fundamentally a tax bill or a tax law. And if it is repealed, Congress is going to need to find revenue to pay for a new healthcare system. And that's likely going to come from high net worth individuals and from international businesses. So we've got a big agenda in 2021, Sean. It's going to be, for me, an incredibly fun year, and I'm very happy to be here.
So a few questions I have based on that, Josh, is when we dealt with the Tax Cuts and Jobs Act in 2017, there were a lot of benefits in there for international taxpayers, individuals that were individuals or families or high net worth family offices. But at the same time, there are other provisions, for instance, the repeal of 958B4 or other changes that didn't really take into consideration high net worth individuals and families. Would there be any reason to expect that to be different right now, or is Congress essentially focused on corporate tax reform, and then the high net worth families and family offices are sort of going to be left to pick up the pieces whenever we see the legislation?
Yeah, so Sean, I think it's actually, there's a problem with who staffs Treasury and the tax writing committees. I don't think there's great awareness of the taxation of individuals, and especially in the family office setting. So I think of GILTI and how GILTI operates and impacts family offices. I don't think there was really any consideration or awareness other than, yes, there are individuals who have CFCs and therefore they'll have to pay guilty. But I don't think there was great awareness of the issues at the time the laws were written. So it really does, it would benefit uh, those who do care about these provisions to weigh in throughout the year through the in Congress and at Treasury. Otherwise, I think we're going to see the same range of errors or ignorance continue to proliferate.
And then the second question I had was really, we just saw with the stimulus package that came through that essentially it had full support in the Senate and reconciliation was used to force this through. Do we expect tax reform to have the same level of essentially Democratic support, or do you expect the concessions would need to be made different possibly than the most progressive Democrats in order to get something through, even with only 50 votes being required in the Senate?
Yeah, so that depends on whether infrastructure will move with tax reform or separate from tax reform. And infrastructure is a bipartisan, generally a bipartisan issue. Members want to see improvements to roadways, airports. In the Northeast, we want to see better mass transit. In the rural communities, they really want to see a better network of rails so there's a range of issues that fit into that infrastructure category that are bipartisan. But Republicans began sounding out a theme at yesterday's hearing. There was a hearing yesterday on manufacturing in America and tax incentives for manufacturing in America. Hearing was held at the Senate Finance Committee, and we heard a consistent theme from Republicans that they do not support increasing the corporate tax rate. And there are a variety of reasons why. One is the economy is in a precarious position. Do we really want to hurt the economy at this point? Second, if we want to improve supply chain in the United States, then is raising the corporate rate going to achieve that goal? So I think we'll hear Republicans push back. And so it's hard to see a bipartisan tax reform bill. So I think tax will be partisan. We'll use reconciliation, and then the question is, will one or two moderate Democrats stand up and defend the business taxes and taxes on and tax increases against high net worth individuals?
Great, thanks, Josh. So just to move this forward, I think obviously there's a lot of things that are coming down the pipeline. I think we're all going to be getting clients, whether you're an attorney, a CPA, a banker. All our clients are going to be reading articles that are coming out in the next few months talking about tax reform, increases of taxes on the rich, and it's ultimately there's going to be plenty of phone calls that are coming up. So for that reason, it's sort of the next step we're going to take is sort of just walking through some sort of problems with today's current structures if the proposals in some of these articles, and that essentially, even though there was no formal proposal released by the Biden administration, when candidate Biden was campaigning, he did talk at various places on his website, had listed some of these tax reform goals. So our clients are going to be interested, and the next few slides are going to walk through some of these changes and essentially how we can be prepared to at least recognize the problems and then be prepared to sort of transition into other structures or other planning mechanisms to make sure our clients are protected. So I think everyone's pretty much heard that there's a lot of pressure to lower the estate tax exemption amount. So under current law, the unified credit in 2021 is 11.7 million. For a married couple, that's 23.4 million with future inflation adjustments, and that sunsets in 2025. The top rate under current law is 40%, and there's a step up in basis in assets upon death. What does this mean for international taxpayers or for non-US persons investing in the United States? Almost nothing, right? So NRAs investing in the United States, non-domiciliaries only have a $60,000 exemption under current law. So for that reason, most of our clients are either in structures that protect them from estate tax exposure or have organized themselves in a way that they have sufficient life insurance or sufficient other means to cover any potential US estate tax exposure. However, one thing to keep in mind here is, for instance, something like the Canadian Income Tax Treaty has its unified credit amount for Canadians investing in the US tied to the estate tax exemption amount in the US. So if this amount lowers, if you have many Canadian clients that are, let's say, owning real estate directly in the United States, they may no longer have estate tax protection with respect to those assets. So it's just something to keep in mind that this isn't something that international clients can dismiss at will. It is something that we should keep in mind for them and essentially keep our clients updated on how at least tax reform is progressing in the United States. I think the potential changes that we're seeing is either a reduction in the unified credit amount. I've heard anywhere from really $1 million to back to the pre-Trump administration, $5 million, with the top rate up to 55%. And then what would be really interesting for international clients is this no step up in basis on death. So much of our planning for international families, particularly where you have a foreign matriarch or patriarch passing assets to US children, is the importance of the step up in basis upon death to allow their children to essentially receive those assets in a state tax exempt structure while also having a step up in basis to reduce their income tax burden going forward. So I'm going to walk through a couple structures that are popular now and sort of identify how a change in law or a change of the step up in basis rule can affect that. So generally, very typical planning for the non-NRA client who comes in and says, or the US-based client who says, my dad lives abroad, my mom lives abroad, she has our family business, or she has all our investments, and she is planning on leaving them to me and my siblings, but we're all American. We came to school in the US, we decided we loved it here, we're staying, or we're moving here, and our children are US people. What do we do? A typical planning structure we'll put in place is a foreign grantor trust. So this type of trust would typically have, let's say we'll use a US domestic asset protection jurisdiction, are becoming more and more popular. So something like South Dakota, Delaware, Wyoming, Nevada, where they'll settle, the foreign patriarch or matriarch will settle a trust in one of these jurisdictions. We'll draft the trust in a way that it will be a grantor trust for income tax purposes. So essentially that means the foreign matriarch or patriarch is subject to tax on the income of the trust as it's earned. But upon their passing, that trust becomes a US domestic non-grantor trust for the benefit of their US family members. And that ensures that the assets in that trust are not subject to the, are essentially estate tax protected for the family members. And at that point, they're also asset protected because they're in one of these US jurisdictions. It ends up resulting in a very tax efficient structure, particularly if you could step up the basis in the underlying assets at the time of the death of the foreign settlor. So best case scenario, foreign settlor is not taxed in their home jurisdiction on the income of the trust. At their passing, planning is placed to step in the underlying assets. Those assets at a fair market value basis, so no more appreciation, are transferred into this trust, or essentially converted when the trust is from a foreign grantor trust to a domestic non-grantor trust. At that point, there would only be US taxation going forward on future appreciation, and the family members are estate tax protected with respect to the assets. So the first example I'd like to cover is sort of on the left side of the diagram here, the foreign asset holdco. So the typical planning here would be a BVI company or some foreign jurisdiction company that would hold offshore funds or non-US situs assets under this trust. And then at the time of the passing of the settlor of the trust, that foreign asset holdco would make what's known as a check the box election to essentially liquidate for US income tax purposes the day before the passing of the foreign settlor. That would allow for, on that deemed liquidation or check the box election, the underlying basis in the offshore funds and non-US situs assets would be stepped up to their fair market value. So for instance, if that trust had $100, if that foreign asset holdco had $100 of appreciation in its underlying assets, all those assets would be stepped up to their fair market value immediately before the death of the foreign settlor. This planning would not be changed because we're relying on the check the box election for the basis step up. So one thing to keep in mind too is that you need to have relevance under the Treasury regulations in order to make a check the box election. So there needs to be some US aspect to this foreign holdco. Usually setting up a US bank account or having some sort of US withholdable payment is a way of accomplishing that. But Seth Enton actually wrote a really good article about this a few months ago, or I guess a year ago now. So you might want to look that up. If anyone wants to see it, you can reach out to us and we'll circulate it. But the reason why that planning still works is because the offshore fund investments or non-US situs assets would not create a state tax exposure for the foreign settlor. So you don't need the foreign holdco there as an estate tax blocker for the foreign settlor, and you could easily step up the basis with a check the box election while maintaining the basis step up and the tax protection. Where things get trickier is if the foreign person or if the foreign settlor is investing in US securities. So this middle structure here has become more popular since the Tax Cuts and Jobs Act, because under the Tax Cuts and Jobs Act, there was a change in the CFC rules that essentially said, prior to the TCJA, there was a rule that said if a US person held a foreign corporation, and that was a controlled foreign corporation, it wouldn't be treated as a controlled foreign corporation at least until it was held for at least 30 days. That rule was repealed. For that reason, the minute that this foreign grantor trust would become a non-grantor trust, the underlying foreign corporations held by that trust would be considered controlled foreign corporations and subject to the subpart F and GILTI regimes. This structure, which we put in place for multiple clients, and particularly for clients that aren't too fee sensitive with respect to having 3 holdcos set up, is essentially protects from this by having the first 2 upper tier holdcos make a check the box election to liquidate before the death of the settlor, which in turn will step up the basis in the underlying holdco to its fair market value. The US securities in the underlying portfolio, what you would first do is you check the box on the underlying US situs asset holdco to step up the basis in the US securities. So that first check the box selection occurs before death at the US situs asset holdco level, the lower tier level. That occurs before death. You still have the 2 upper tier holdcos to protect the foreign settlor from estate tax exposure with respect to the US securities. After the death of the settlor, so now the trust would be a domestic non-grantor trust or a US taxpayer, the 2 upper tier holdcos would make check the box elections, and this would trigger essentially any additional appreciation you'd have a basis step up on death. So there'd be no appreciation in the stock of those 2 holdcos, and any additional appreciation in the underlying US securities that occurred during that year would be essentially prorated throughout the year as subpart F income. So if someone dies in the first 75 days of the year, this structure allows you to make your first lower tier check the box selection back to the prior year to avoid any subpart F income. If someone dies or if the settlor dies after the first 75 days of the year, the maximum tax you would pick up in exchange for a full basis step up would be 1/76 of the appreciated underlying portfolio. So this is a quite efficient structure under current law. If we lose the basis step up, all of a sudden those 2 foreign tier holdcos at the upper tier level would no longer be eligible for that basis step up. And when you check the box on those entities, you would trigger capital gains on all the in the portfolio as subpart F income. So you'd still have the estate tax block, or at least you would trigger it for the year, the full, you'd lose the benefit of having the 75-day protection. So for that reason, this structure has lost some of its appeal if there is a basis step up repeal. And for that reason, it's important that clients who are in this structure, or if they don't have the 2-tier structure and just have an underlying US holdco and are essentially churning their assets to get around the risk of subpart F income, that they speak to their advisors to ensure that they don't, essentially, if we lose the basis step up, there's other planning that would need to be put in place to essentially preserve a basis step up while providing estate tax protection. We have some ideas, but I think it's a little bit outside the scope of this presentation, but we'd be happy to discuss them with anyone offline if they're helping prepare their clients for this. And then the last structure worth discussing would be, so we have an anonymous attendee asking why a 75-25 versus a 100% holdco. And that's the reason for that is if you have a 100% holdco, when you make the check the box selection on the lower tier US Citus asset holdco, that would be considered a 332 liquidation for US tax purposes. So essentially when you liquidate an 80% controlled subsidiary, you don't get a basis step up in the underlying assets. And instead, the upper tier majority owning shareholders, so if it was an holder or just 100%, you would have the assets transferred to the upper tier holdco at their current basis, and you would lose any benefits of a basis step up. So thank you for that good question. If anyone else has any questions, by the way, we intended for this to be interactive, so please put your questions in the Q&A and we'll try to get back to you as soon as we can. And then the final structure I wanted to touch on here was the real estate blocker corp, which is our structure right now for clients investing in US real estate, where essentially you would have a foreign holdco as the blocker for estate tax purposes, and then usually a USC corporation that would own the underlying US real property. Once that real property would be sold, you'd have 21% tax under current law and any state and local tax. And then after all the real estate is sold, and that US real estate holdco would no longer be a US real property holding corporation for FERPTA purposes, that company could be liquidated into the foreign parent without triggering any additional US tax or withholding tax. If we move to a world where you 28% corporate tax rate or no basis step up, this structure should also be reconsidered. One other thing to keep in mind here that's become a quite popular strategy, particularly with the foreign grantor trust structure, is when US children inherit a US real estate blocker corp. So if a foreign parent is owning their condo in Miami Beach through one of these structures with a BVI company that owns a US corp, when that gets left to their children that are US people, owning it through a BVI corporation is pretty tax inefficient. But you can't make a check the box election before death, because then the foreign parent would have US estate tax exposure. A strategy we've put in place, and a lot of practitioners have put in place, is that BVI company, which is the blocker corp, which also step up now, would domesticate and become an S corporation while held by the US trust or by the US family members. At that point, if the real estate is significantly appreciated, you could wait out 5 years to sell the real estate to have capital gains on the real estate sale. And then also you could liquidate the S corp, which has now had a basis step up and a second basis step up to the extent of the gain in the real estate. And you could trigger a capital loss on the liquidation of the S corp. So that planning could also be affected by the loss of the basis step up. These are the types of things we're thinking about, we're preparing for right now. We're hoping, actually, I think we might be the only people that want the rules to be as complicated as possible. But with that being said, I do think that it is something that's important, particularly for the bankers on the line and for the non-tax practitioners, to keep in mind that client structures, which might be very appealing under current law, may not be appealing a year from now. And also another thing to keep in mind, particularly for the international client, is to stay in constant contact with their foreign advisors to make sure that anything we may put in place or any tax reform that we have in the US doesn't negatively affect them when repatriating income back home. So quickly, I'm going to run through the individual income tax proposed changes. There's one here that stands out more than others, but essentially the Biden proposal increased the top rate to 39.6%, phase out the 199A deduction above $400,000 of income, and limit some itemized deductions. The one thing I'm getting most calls from our clients and what people are most scared of is this idea of getting rid of capital gains rates. So we understand, and particularly with something like reconciliation, and Josh can chime in on this, what I've heard other people say is that if the capital gains rate increases above 28%, one, those moderate Democrats likely will not support it, and two, it may actually grade out from a revenue perspective for the when you have budget reconciliation and legislation comes through to under the reconciliation process, it needs to be revenue neutral with respect to the budget. My understanding, and Josh, you can correct me if I'm, is that if the capital gains rate goes too high, it actually may be a negative revenue generator for the Treasury. So that's something to keep an eye on as well.
Yeah, Sean, and I think it's important that we don't know how much revenue Congress will seek to raise through the reconciliation process. So we saw, for example, with the TCJA, that Congress set a revenue loss of 1.5 trillion during the budget window, and anything outside the budget window had to not add to the deficit. And that's basically the Byrd rule in a nutshell, that that we cannot add to the, more one of the issues in the Byrd rule, but we cannot add to the deficit outside of the budget window of 10 years. So so you're correct. There's eventually a grade out, so to speak, and individuals will not want to sell assets. They will hold, and that will then drive down capital gains receipts. So so it's unclear what the magical rate is. There's a lot of literature on that point by economists. I don't think there's an agreed upon rate, but we do know that if we were to equalize the capital gains and ordinary income rates, that would create a disincentive to sell, and so that could potentially reduce revenues. So there is a tipping point. I don't know what it is. I've heard 28% is the magical rate, and anything in excess of 28%, we start seeing diminishing returns. But that's going to be a hotly contested issue.
So thanks for that, Josh. So one thing to keep in mind here, particularly for our international clients, we've struggled to figure out a way to repatriate income back to the US in a tax efficient manner. And a lot of the popular strategy has been to use qualified dividends, right? So paid by a foreign company in a treaty jurisdiction are subject to tax at capital gains rates. If dividends are paid by a foreign corporation in a non-treaty jurisdiction, those are subject to tax at ordinary income rates. If the capital gain rate increases to the same level as the ordinary income rate, this qualified dividend planning benefit is essentially lost. One thing many practitioners put in place particularly for clients that have successful businesses abroad after the Tax Cuts and Jobs Act, whether it was through GILTI or through just the typical Subpart F regime, a lot of our clients realized it was beneficial, considering the 21% corporate tax rate, to own their foreign companies through a USC corporation. If qualified dividends are not available, or if dividends from a US corporation are taxed at a 28% rate, or even potentially a 39.6% rate, we've all of a sudden locked some of our clients into a corporate structure that also will not provide the benefit of reduced taxes on a repatriating dividend from a non-treaty jurisdiction. So that's something to keep in mind for our international clients, that we should keep close eye on qualified dividend planning. And also, and another thing to keep in mind there too is US corporations under the 245A deduction do not pay tax on certain dividends paid by foreign corps. So for instance, if you had a client based in Ecuador which is not a treaty jurisdiction, that were to pay a dividend out to a US corporation out of underlying active profits, it was possible to interpose a US corporation, not have tax at the corporate level, and also qualify for qualified dividend treatment when that US corporation taxes to a family office, paid a dividend to a family office. That type of planning might not be available, and it's important to sort of stay ahead of this to make sure that all structures are as flexible as possible in the event that we do lose these benefits going forward. And also if the corporate tax rate increases, to make some of those structures less appealing. And just to move to that, so as Josh said earlier, the main proposal from a corporate tax rate, and this was on the front page of Bloomberg yesterday, that Biden is looking to increase the corporate tax rate to 28%. What does that mean for us? A few things. One, current structures where C corporations in place would be less efficient. Two, we may have a less competitive jurisdiction for foreign investment. And there's also some scary stuff with respect to some foreign jurisdictions have their local controlled foreign corporation regime linked to what a US tax rate is. So this actually might knock some companies out of being a controlled foreign corporation. And for instance, Mexico comes to mind. If a Mexican investor is invested in a Mexican CFC, they actually have a more preferential tax credit regime than they do if you're not invested in a CFC. So you may get some deferral by not being in a CFC, but it could affect the tax credits at home. So we've done a lot of planning for, or when we have Mexican clients, we always try to think about this type of situation. We typically involve our colleagues in Mexico to make sure that everything is efficient as possible. But as the US corporate tax rate moves, any of these international structures that we have in place for clients could either become more or less efficient. And then the last thing to keep in mind is a lot of people with respect to GILTI planning assume that if I have a corporation in place, because the US corporate tax rate is 21%, under the GILTI rules, you get an 80% credit for taxes paid on GILTI income abroad. So essentially, if any US taxpayer, any USC corporation owned a foreign subsidiary that was paying taxes at a rate that 21% was less than 80%. So essentially, if someone's paying tax over 26% abroad at the corporate tax on corporate taxes, they would be able to fully credit against their GILTI exposure in the United States. If we have a 28% corporate tax rate, we may be left in a place, and I know there's also some discussion of getting rid of the Section 250 GILTI deduction. So if these changes are put in place, a lot of our clients that own their foreign corporations through USC corporations could end up paying GILTI tax on income that they weren't expecting to ever pay tax on under the TCJA. So this is something important to keep in mind, and Josh can touch on some of the proposed GILTI changes that we should be keeping in mind for clients.
Absolutely, Sean. And the GILTI is, it's interesting. When the TCJA created GILTI, it created a law that has a series of gears, and those gears or dials, and they can be turned in different directions, making it a more favorable regime or a worse regime. So let's talk first about country by country GILTI, which would be a fundamental change. So current law, GILTI is effectively a one CFC approach. It allows for loss companies to be netted against gain companies, which is important because GILTI does not have a carry forward mechanism for losses or foreign tax credits. Second, it allows for cross crediting, which is great. That's what tax professionals and high net worth individuals like to do. And so this would be a very significant change to move to effectively a country by country approach. We would mean an instant increase in GILTI for many companies and high net worth individuals. It's unclear how foreign tax credits would be impacted. And before I get to QBI, I do want to link to the foreign tax credit piece. So the Biden administration supports moving to country by country. The Biden campaign plan was silent on the treatment of foreign tax credits. That obviously matters because if you're in a high tax country, say a France or a Germany, ideally you would like to get the benefit of those foreign tax credits. The full benefit, are they still going to be haircut, and are you still going to get an 80% benefit of those foreign tax credits? It's unclear. Country by country would increase complexity. It would require system designs for those with complicated structures. It is not going to be a simple flip of the switch, especially for multinational corporations that could have 2,000 to 3,000 CFCs across the globe. Another change is potentially to QBI. There's been a theme that we're hearing that perhaps eliminating QBI would bring back manufacturing to the United States. Also, if you look at what is happening at the inclusive framework, QBI is part of an element of a top-up tax or what is our GILTI. It is not a requirement. So I think the question is, does the Biden administration want to retain QBI, or is this going to be a tax on $1 return at the CFC at the CFC level? That would be very expensive.
For the non-international practitioners on the line, just to touch on what QBI is, essentially, if you have a foreign corporation that has tangible assets, you're allowed a deemed return under the GILTI regime with respect to those tangible assets that are used in your business, which essentially gives you some deferral before you hit the GILTI tax.
Yep, thank you. And effectively, it's a hurdle rate. So once you get over the hurdle, you get the detrimental rate. But anything that's before the hurdle, so if you have a low margin manufacturing, then that return is completely exempt from U.S. tax. So that would change the calculus for low margin manufacturing and would make them subject to immediate U.S. tax. Effectively, eliminating QBI is just eliminating deferral or our territorial system altogether. And I think there is a question: should we move to a worldwide system? Because that might be easier than a GILTI system. And I think there'll be a discussion of that. I'm not advocating that, just so we're clear, but that is a discussion that I think we'll hear from the business community. It's worth noting that at the OECD, the Inclusive Framework Pillar 2 has a top-up tax, which is similar to our GILTI. It's the top-up tax has a country-by-country approach instead of a one CFC approach or one foreign corporation approach. Once again, QBI, or the return on tangible property, is a optional building block. And then there's a backup rule, a backup tax, or the undertax payment rule, which looks very much like our BEAT, except it's targeted to low tax jurisdictions. So if a payment is made from a high tax jurisdiction to a low tax jurisdiction, then the high tax jurisdiction could deny a deduction for that payment or impose withholding taxes, either way. So those changes are on the table, and I think we'll begin to hear the theme of those changes and what the Biden administration would like to accomplish next Tuesday at the Senate Finance hearing.
Great, thanks, Josh. And one thing I want to touch on as well that Bill pointed out in our Q&A is increasing the corporate tax rate to 28% would also have grave effects with respect to the high tax kickout from Subpart F and the high tax kickout from GILTI. I know the Biden administration actually is potentially going to legislate. The high tax kickout in the GILTI context is a regulatory change, so that might even get repealed. But in the sub context, any jurisdiction with 90% of the U.S. corporate tax, with a corporate tax rate of 90% of the U.S. corporate tax rate, that income can remain deferred from being treated as foreign personal holding company income and subject to Subpart F income or any other type of Subpart F income. So if we increase that to 28%, that 90% number for the high tax kickout increases as well. This could be pretty significant for individual investors that are investing through CFCs abroad, because you could end up in a circumstance where income that would have been deferred will no longer be deferred. If it is Subpart F income, then you pick up the tax immediately on that income. Or if a section 962 election was made with respect to some GILTI income, you would end up essentially needing to make a 962 election instead of having the high tax kickout on the GILTI side. And this could result in higher taxes when dividends are eventually paid. And if those dividends aren't eligible for qualified dividend treatment, we could end up, when we're modeling for clients, a much higher effective tax rate than under current law. So it is kind of scary to think of what may be coming for cross-border taxpayers, particularly for individuals and family offices. And we're trying to stay one step ahead of it. And it's great that we have Josh up in DC, who's going to be able to give us updates of what's happening on the Hill.
It's definitely going to be a busy period. And Sean, actually, you did raise a good point about the high tax kickout. Everything we've discussed is legislative, but there's a lot more latitude on the regulatory side. And I expect that this Treasury, now that they are almost up and running, and we'll have an Assistant Secretary for Tax Policy sometime in the near future. Lily Batchelder will be confirmed hopefully will be confirmed at some point. Then we will see Treasury decide which regulations they would like to modify. And we've seen in articles in the Wall Street Journal and other publications that that folks advising then candidate Biden are interested in revisiting the policy call on the high tax kickout. There are other regulations as well that are likely to be in the crosshairs, possibly in the foundation side. I think there's a view on the individual and foundation side specifically that the prior administration was quite generous in some of the policy calls. So we could see a reconsideration of various regulations and sub-regulatory guidance.
Great. Well, thanks, Josh. And that's all we have. I don't know if we'll give another minute to see if any Q&As come in, but our information should be on the webinar invite and the registration. And if anyone has any questions, you can reach out to us at any time. We'll be sharing updates on legislative guidance as anything comes down the pipe. And if any of your clients have questions with respect to potential changes in the international tax context or the domestic tax context, we're always available. Thanks, everyone.